There are three compliances milestones, basically 0, 12 months, and 18 months. So now what the organizations need to do? They have to comply with this DPDPA rules, and the phases which government is telling are three phases. One is immediately, and next is within 12 months what we need to do, and next is after 18 months what you need to do. So if you see the milestones, it starts in the month of November. So 13th November was the zero date. And then when we take 12 months from there, it becomes 13th November 2026. And we take 18 months from there, it becomes 13th May 2027. So by 13th May 2027, we all have to become compliant to DPDP acts. Now, phase one is effective immediately. Since this particular thing, which Rudramani has told that today we are going to discuss the timeline and what are the phases which are effective for DPDP implementation. So these are the phases which has come as per the part of the rules. So rule number 1, 2, 17, and 21 took effect upon publication immediately. So already the constitution of the board and other things have already taken place, and those things are already put in place by Government of India. So what has happened in that definition and commencement provisions clarify scope and applicability, board establishments, data protection board formally constituted with with appointment powers, administrative framework, chairperson, member appointments, digital functioning procedures, meeting protocols, and staff authorizations. This has been done. For this, actually, organizations don't have to do anything, and that is the part of the Government of India, and they have done this. Phase 2. This is about the consent manager ecosystem. Basically, we are talking about rule number 4. Now, in data privacy, when a fiduciary is collecting data of personal nature, whether it is a individual's data, or it is the employee data, or it is a child data, or a person with a disability, the data belonging to the person with disability, whatever data you are taking, there has to be a consent form. There has to be a consent management framework. There has to be a consent management platform available in the ecosystem. So this is what government is thinking, that it will establish within the period of 12 months. That is by 13th November 2026. Now, what we all need to do, actually, consent manager authorization is one of the process which the government is doing right now. You must have heard that TCS and Reliance Jio, they have applied for becoming consent managers. So once the content managers, they put the platform in place, that particular platform needs to be integrated with the organizations, with individual organizations. So who can register for a consent manager? A formal registration process with data protection board has to be done. Eligibility criteria, they have put minimum net worth of 2 crores and technical capability standards, operational duties, interoperable consent platform development and user rights facilitation, and board oversight. Continuous monitoring and compliance verification by regulatory authority. So organizations pursuing consent manager status must begin with preparation immediately, including capital requirements, technical architecture planning, and interoperability testing. Now, here organizations will have issues. They have to see that their digital platforms are integrated with the consent manager platform. Now, you must be wondering that organizations which are small in nature or medium in nature, who don't have the volume of the data, or the personal data may be less for many organizations, they need not go for the consent manager platform which are available in the third party. Consent management platform which will be available in the third party will help you in streamlining the process. They will take care of all the headaches of taking the consent, modifying the consent, and actions based on the content has to be done by the fiduciary, but all other things about the consent has to be done centralized. So that's why the consent manager platform is coming up. But you can have your own consent management system in your own organization, and then you can implement that as per the act. Full compliance. So we talked about the rules which were there in the phase 1 and phase 2. We now let's talk about the rules which are there in the phase 3. So full compliance is expected by you by 13th May 2027. Rules 3, 5, 16, 22, and 23 will get activated after 18 months, bringing comprehensive obligation into force. This marks the beginning of enforcement and penalty exposure. So, Rule 3 talks about the privacy notice, detailed disclosure requirements for data collection for processing. Rule 5 talks about government standards, processing protocols for public sector entities. Rule 6 talks about security safeguards, mandatory technical and organization security controls. I think in the audience, we have people from different organizations. I think you will agree with me that there is not a single organization right now who are having digital processes, but they don't have security, information security. Everybody has some information security or the others. So what are the controls you have put for information security? Those things will come under rule number 6. So whatever existing controls you have in your organization, like access control management, your asset management, your inventory management, your risk management, we talk about incident management, we talk about data masking, we talk about data leakages, we talk about your VAPT controls and other controls which you have put in place. All those things will come under Rule 6. So Rule 6 is basically a technical rule which you can map to your existing rules which are already existing in your organization. So the next one is breach notification. Of incident response also you have and reporting timelines to the authorities and the users are something new which you need to look into in the act. The retention and deletion, if you're having ISMS, if you're having information security management system in your organization, I'm sure you have a retention and deletion policies, but not those things needs to be aligned to DPDPA Act. Contact person, this is something new. We didn't have data protection officer or a point of contact. So we need to have a DPO or a point of contact. Here, there is a small deviation. Now, supposing do all the organizations need to have DPO? The answer is no. But you need to, all the organizations need to have a grievance officer. Supposing any dispute results because of personal data and all that, then we need to have a grievance officer. A DPO is required for significant data fiduciary. Now, data fiduciary and significant data fiduciary is again dependent on the definitions of Data Protection Board. So they will decide who is SDF. SDF basically, if you're having a social media website which are having more than 2 crores members, or you're having an e-commerce website which is having more than 2 crores, then those criteria are being used to define SDF. So when you have the SDF, then definitely you need to have a DPO also in place. Child consent, anybody less than age of 18, we need to have a child consent. The parent has to be identified. The parent has to be identifiable online. So who can give the consent for the child data which is processed in different websites. Disabled persons, again, the identifiable guardian should be there. Child exceptions, limited exceptions for child data processing. There are some exemptions also, which comes under rule number 12. Rule number 13, SDF obligations. What are the obligations for the SDF once they have taken the data from you? What are they supposed to do? What they are not supposed to do? All those things are coming in at rule number 13. Rights and grievances, data principals, they have right. Data principals will have grievances. So all those things are coming in rule number 14. Then cross-border international data transfer restrictions and safeguards are put in rule number 15. There are other rules from rule number 16 to rule number 23. So rule number 16 talks about the exemptions, and then 17 to 23 basically talk about the constitution of Data Protection Board and the members' salaries and other things, their compensations, all the things are coming under rule number 17 to 23. So these are the timelines, phase-wise, phase 1, 2, 3. I think this chart is visible to you. Rudramani, is it visible to you?
Yes, yes, Mr. Sudhanshu.
Yeah,
It is
yeah.
visible.
I'll just give you 1 minute to go through this. I'll just come back shortly. It'll take 1 minute to go through this chart closely. You can see this shows a very clear timeline when the draft DPDP rules came out, when the notification for DPDP rules, and then what has to be done immediately on day 0, 12 months, 18 months. So this is the timeline, and if you see the activities which are there, again, consent management, SDF, security safeguards, data principal rights, children's data, data breach reporting, cross-border transfers, and penalties. This has been taken from LinkedIn, but it gives a very nice depiction of the implementation roadmap and the key developments and the key areas are clearly marked in this. Understanding the timeline, the phase implementation creates a compliance staircase where obligations and enforcement intensity escalate over time. Each step represents a distinct risk profile for organizations. Immediate regulator formation phase, organization face no penalties, but should begin strategic planning and internal assessments. Consent manager infrastructure activates, organizations must plan integration strategies. So yes, consent management platforms are coming out, but we need to have integration strategies right now. We need to see that our software, our process flows, our data flow, whether it will integrate with the consent management platform or not, or are we going to have our own consent management platform in our websites. Uh, all obligations apply full enforcement penalties under DPDPA Act. Yeah, I mean, one common question which I hear from people is that when do we become fully compliant? Is there any certification for this? So no, they are not telling that you have to get audited or you have to get certified for DPDPA, but it is good to have internal assessments, reviews, and it is not that whether you're certified or not, it has to be 24/7 safeguard has to be put in place. So yes, when does the Data Protection Board invoke this act? They will invoke this act when there is grievances, when there are penalties, then this act gets invoked. So we have to see that we are compliant with the act with the help of maybe ISO auditors or internal auditors, reviews, and maybe in the ecosystem, certain auditors will also come, but it is not mandatory to have a DPDPA audit. Yes, if you are SDF, then you need to do uh, uh, data protection impact analysis. DPIA has to be done annually. That is one thing which needs to be done annually, but that is not a kind of audit program. Compliance roadmap, GRC perspective, assessment. So now basically now we are coming to how to implement this. So are we going to wait for 12 months? Are we going to wait for 18 months? Or are we going to start now? Naturally, we have to start now because those are the deadlines which are given and those deadlines are mandatory. People have to become compliant by that time. After that, any breaches or any grievances happen, naturally, it will result in penalties. Okay, so the punishment right now is penalties to the extent of 250 crores. And uh, as they say, it is not a criminal act. It is a civil law. It is not a criminal law. So I don't think there is any imprisonment and other things. But the penalty and the loss of reputation is used. Going forward on this, successful compliance requires disciplined execution across 18 months preparation window. This roadmap structures activities into quarterly phases. So you can take it quarterly phase, baseline and gaps. You can identify what is the baselines, what are the gaps, what are the controls required, and what is the roadmap for implementing of the controls. Then you deploy the controls, and then you're ready for the compliance. So this is basically a broader way of talking of implementing 0 to 6 months and 12 to 18 months of the framework. You can adapt this, but I have made a small implementation phase presentation for you. So you can adapt that. Basically, all organizations may not need 12 months or 18 months. They may require less time depending on the size of the organization. So, but there are certain steps which needs to be done. So I have divided that into 6 steps, which I'll be sharing with you. It is mandatory, not optional. It is the timeline is generous, it appears to be generous, but it is very firm. And it is a combined framework. The Act and the rules function as an integrated whole. Act tells you what to do, rules tells you how to do. So that is how I'll advise all of you to go through this the Act and the rules. They are basically 20 pages, both of it. And you will understand a lot of things from the Act, legal words, other things also. So yes, the high impact areas are listed here: SDF obligations, security safeguards, breach notification, retentions. So rule number 13, 6, 7, 8. Rights handling, rule number 14. Consent management ecosystem is one of the governance framework which is going to come up. Organizations must begin preparation immediately to meet 18-month compliance deadline with fully operational controls, trained staff, and tested procedures.